Rhadisha Maurrasse. This is W 2021-000-292-1214. May I have your appearances, please?
Good morning, Your Honor. For the state, Assistant Prosecutor Scott LaMountain.
Good morning, Mr. LaMountain. Good morning, Your Honor. May it please the court, Michael Policastro on behalf of Rhadisha Maurrasse, and she's appearing live on Zoom from the Middlesex County Corrections.
All right, state, can you establish probable cause?
Certainly, Judge. The state submits it on April 19th, 2021. New Brunswick Police Department responded to reports of shots fired / motor vehicle crash at the intersection of Handy Street and Paul Robeson Boulevard in their city. Upon arrival, officers observed a 3-vehicle crash in which the driver of the third car, later ID'd by the initials D.A-L, who had been shot in the neck. He was transported to Robert Wood Johnson University Hospital, where he was pronounced deceased. Both the New Brunswick Police Department and Middlesex County Prosecutor's Office major crimes detectives were notified, and they responded to the scene to conduct an investigation. Detectives first interviewed an individual with the initials CS, who was one of the original 911 callers notifying the police of the incident. She indicated that she was driving in her car past the residence on Handy Street with her boyfriend when she observed this defendant stand up, pull out a gun, and begin shooting at her vehicle. She stated that she then pulled around the corner and called the police. During CS's formal tape statement, she indicated that she knows the defendant since she used to date her brother. She also stated that earlier in the day, this defendant was sending threatening messages to her through Instagram. Police also interviewed an individual with the initials HR. He indicated that he was riding on Handy Street in a vehicle with CS, the prior witness, when their car was struck by bullets. He stated that after hearing shots, he observed a female on the porch of the residence where the shots came from. He told police he recognized this female as someone who his girlfriend, CS, had prior disagreements with. Detectives also interviewed a bystander with the initials SS, who stated that she was walking on Handy Street with her daughter when she heard gunshots. She indicated that she observed a woman on a porch shooting, at which time she ran behind a building and hid. She came out and observed the same woman come out of the residence and back onto the porch, at which time she pointed this woman out to detectives while indicating that's the same woman that fired the shots. Detectives also interviewed an individual with the initials JG-G, who was a passenger at the victim's car at the time he was shot and killed. Investigation indicates that the victim was some type of cab driver or Uber driver or something where he was provide rides for money. This individual, who was the passenger in the car where the victim was shot, also stated that he observed a woman on the porch of the gray house firing a weapon, and that he then ducked down, and that while he was ducking down, the car he was in crashed. Police went in to speak to the woman who was on the porch, who witnesses had identified as the shooter. She was brought back to New Brunswick Police Department, where she provided a statement after being read her Miranda rights, in which she admitted to firing the shots at the car containing CS and HR and CS. She stated that the two had been harassing her and that she shot because she was in fear of HR. She told detectives where in her residence the gun would be located. Detectives obtained a search warrant from a Superior Court judge, entered the residence, and the gun was found where she said it would be. The state submits that there is sufficient probable cause for all the charges stated in this complaint. I would like to point out to the court that this complaint was approved in the middle of the night, Judge, and that after the initial complaint for murder, weapon, and weapon unlawful purpose was signed, 2 additional charges for attempted murder, the victims being HR and CS, has also been signed and filed.
All right. Mr. Policastro?
Judge, I stipulate to the probable cause in this case portion.
All right. Court finds that their probable cause has been established based upon the state's proffer as to the charges and also the defense's stipulation. Here, the court finds probable cause that on April 19, 2021, defendant shot and killed the victim. Numerous witnesses identified the defendant as the shooter, and the defendant, in a Mirandized statement, admitted knowing the defendant knowing the victim, and also being threatened by the victim. Further, the defendant told the police where the handgun was located, and the handgun, in fact, was recovered. As this defendant is subject to life imprisonment, defense, can you tell me why she should be released?
Yes, Judge, thank you very much. Your Honor, a couple things. I'm agreeing with, most of the things that Mr. LaMountain said, or a lot of them, but not all. And I just want to tell you on a couple additional things. I don't know if you got them, but I did get some letters of support from people in the community, which I emailed, I believe, to Judge Flynn yesterday, that she does have extensive ties to the community. She's 35 years old. And, I didn't get her criminal case history, but I don't know if she has it. Do you know, Mr. Mount, does she have prior felonies? I know she has some minor charges. Are they felonies?
She has a prior disorderly persons for theft,
Mm-hmm.
one prior failure to appear, and one prior sentence that resulted in incarceration for over 14 days. And all three of those might be on the same theft charge.
Okay, and I do say here, so Judge, I don't think she has any felony charges on her record. She's working as a medical care driver. She lives with her sister, and she was living with her mother. She has 4 children, Your Honor. Let's see. She's never been out of the country, nor does she have a passport. So I'm just trying to address that. I don't think she's a flight risk. Although I see in the failures to appear that she does have one dating back, according to the PSA report, to 2005. She said that charge was later dismissed and there was a notice problem. So I would ask Your Honor, don't give that one a lot of weight. I'd also like to let Your Honor know that, like what Mr. LaMountain said is true. This was a mistake. She says that this person in the car, who's a prior felon multiple times, has been threatening her and her family for a long time. And she stated to the police when she voluntarily walked in there and gave a confession that she saw him pull a gun at her. So I think even the prosecutor, we may disagree on certain things. I think he also knows that this was an accident. This was nothing deliberate or anything like that, but that she felt fear. That's what she told the police from the gentleman in the car, that there's a history. He's been recently tormenting them, coming by, making threats to her and her family. And she said she honestly believed he had a weapon, a gun she actually said in her hand, and was reaching for it. And that's why she did shoot. She said she was, if you see her, which I watched, her statement, she was crying, totally remorseful, did not intend for anything to happen. But, it's tragic what did happen. I would ask Your Honor to consider level 3 ankle bracelet, home detention, to allow her to help me and prepare in her defense. Like I said, she's 35 years old. She has no prior serious charges, nothing violent ever on her record. She does have 4 children, ties to the community. I mean, what happened, Judge, is horrifying, that an innocent person, with children of his own. I mean, we can't get over that. It's disgusting. But I think Mr. LaMountain, I'm sure, also saw her statement, extremely remorseful. She did not intend this to happen. The issue here is, whether or not she was justified. If she's on her house, somebody pulls by in a car, and as she said, was pointing looked like reaching for a weapon, who she's had made prior threats to her, who, according to her, I don't know this yet, has an extensive criminal past. So that's where we're at, Judge. I ask you to consider whatever you could do to allow her to remain out until we resolve the case. Thank you.
Thank you. Mr. LaMountain.
Judge, the presumption is that this defendant be incarcerated, and I would ask that she remain incarcerated. She's facing a crime in which she's facing a life imprisonment, Judge, possibly. This is your textbook transferred intent case, although it can be phrased, I guess, in some respects that it was an accident that she hit and killed this innocent man who's just working, trying to earn a living and driving past her house at the wrong time. But she certainly acted with intent when she fired a loaded handgun at the two other victims, CS and HR, who were in the other car, Judge. This case just is mind-boggling to me that in broad daylight with people out on the street, she sits on her own porch and decides to fire a gun out into a car like it's the Wild West. I will concede that her record isn't the worst, Judge. She does have a Superior Court ag assault that was eventually dismissed in 2004, 2006, a theft. That it looks like she got county time on the DP. There was an arrest in, it looks like 2010 for hindering. She got PTI on that. Then 2014, there was a municipal court in Somerville that was eventually dismissed. So she has had prior dealings with the law, Judge, but this is about as serious as it gets. Again, there's lots of motive to flee the jurisdiction when you're facing life in prison, and the state is asking that she be held pending her trial.
Thank you. It's the defense's burden to prove by preponderance of the evidence that there are conditions that will assure community safety, appearance, and adherence to the orders in cases where the defendant is subject to life imprisonment, as defendant is in this case, since she's charged with first-degree murder. This matter comes before the court on the state's motion for detention. I've already made my findings with regard to probable cause. Having made that finding, the next step is to determine whether the state has rebutted by clear and convincing evidence the presumption against detention. However, in this case, it is the defense's burden because of the first-degree murder charge. The PSA provides guidance to the court. On this PSA, the defendant scores a 3 for failure to appear and 3 on the risk of new criminal activity. Going through the factors of the nature and the circumstances of the offense charged, again, this is a first-degree murder charge. The weight of the evidence is strong. There are numerous witnesses to this case. Also, the defendant actually admitted to the crime, admitted to where the weapon was, and the weapon was recovered. The history and the characteristics of the defendant, I do note the criminal record of the defendant is not great. She has a prior theft, which was a disorderly persons offense, and back in 2006, and a there was an FTA that was back in 2005. However, she only scores a 3 and 3. However, based upon the totality of the circumstances, the court is satisfied that state has rebutted by clear and convincing evidence the presumption, the evidence against the presumption against detention. Or in other words, the court finds there are no conditions that will assure community safety, defendant's appearance, and that she will not obstruct the process. Therefore, you are being detained. Ms. Maurrasse, you have 7 days to appeal this decision. So you are being detained. Is there anything else I need to address?
No, Your Honor.
All right. Thank you.
Thank you,
Thank
Judge.
you, Your Honor.
Thank you, Mr. Polecastro. Have a good day.
I'll give you a call, Ms. Lamountain. Thank you.
Okay, thanks.
All right.
All right, who would bring next?